Hey guys, and welcome back to today's video. Today we're revisiting a sovereign citizen I covered last Friday, Jeffrey Zunick. In that video, he refused to appear in court in person, even after being ordered by the judge, and claimed that if he showed up, the court would kidnap him and throw him in jail SO. I went back to my archives to figure out exactly why he said that. And it turns out it all goes back to a probation revocation hearing that did not go in his favor. Today, we're breaking down that hearing so you can get the full story. So let's get started.
Is there anybody else that is here on the docket besides Mr. Zunick? Okay. All right. Then the next matter, I think the last matter that we had on the 945 docket is the matter of the People versus Jeffrey Zunick. It's a revocation of probation hearing. Mr. Zunick, are you present?
Yes.
Okay. Why don't you come forward and have a seat at the table?
I have a notice, Your Honor, that I'd like to file with the court
Okay.
for the record.
Okay.
Mr. Damon.
Thank you. I'm going to take just a minute to review that, Mr. Bame, if you would too. All right. Can I have the appearances of the party beginning with the People first?
Matthew Bama, 41464.
Okay. And Mr. Am I saying it correct? Zunick?
Zunich.
Zunich. You're Jeffrey Zunich, correct?
Yes.
Okay. And so we are recording the proceedings. We don't have a court reporter here. So I'm going to ask you some questions, and if you could just make sure you speak into the microphone so that we capture everything that you say. Prior to the start of this matter, Mr. Zunich presented us with a letter, a copy to the People and a copy to myself regarding his grievances about the process which is about to take place. Mr. Zunich, we're here on a hearing on a revocation of your probation. The laws of Colorado set out the procedure that I'm required to follow when that kind of allegation has been made against you. This allegation was first made in an order regarding the complaint of probation was filed on November 25th of 2025. And then there was a summons where you were served with a filing of the complaint of probation. Have you had a chance to review that complaint?
Yes.
Okay. So what we do when we have an allegation that somebody has violated the terms and conditions of their revocation hearing is that the court has to make sure that you first understand what the allegations are, and then I make sure that you know what your rights are and the potential consequences if I determine that you have violated your probation. And then I'm going to ask you how you want to proceed. And there's basically two options. One, you can plead not guilty and we'll have a full-blown hearing, or you can plead guilty and then we can make a determination of whether or not your probation should be revoked or revoked and reinstated. And that's what we're here to do this morning. So let me first make sure that you understand what your rights are when we are dealing with an alleged probation revocation. In a revocation hearing, this is a little bit different than when it's a criminal matter, because in a revocation hearing, the only thing that you would have is a hearing in front of the court, and the court makes a determination by a preponderance of the evidence whether there's sufficient evidence to establish that a violation has occurred. So you have a hearing, but you don't have a trial. But the other rights that you would have available to you, just like in any criminal matter, still exist. You have the right to remain silent. You don't have to say anything, and anything that you do say could be used against you in the court of law. You have the ability to subpoena witnesses, to confront those witnesses and cross-examine them. You have the ability to call your own witnesses to testify on
I was
your
denied
behalf.
that in the original case way back.
So I can't do anything about what transpired in the original case. I can only
The
talk
judge
about,
has since been released for misconduct, and one of the arresting officers is absconded from justice.
Yeah, neither of those things matter. The only issue before court today is whether or not you violated the terms of probation that you agreed to. And if you did violate them, then the next step is deciding your punishment.
so the only thing that I can do for you here today is address the revocation of probation. That's the only thing that I'm authorized to do at this point in time. And so I'm just going to tell you your rights that are associated with this hearing. So in addition to the cross-examination rights, I've talked about the right to remain silent, the right to a hearing. You have the right to persist, in your not guilty determination. And if I were to make a finding, you would have a right to appeal that particular finding. It's the burden on the prosecution to establish by a preponderance of the evidence that that's been violated. Do you understand your rights in this matter?
I comprehend them.
Yeah, I'm not asking if you agree with them, but whether or not you understand them. And you indicated that you had reviewed a copy of the complaint. Let me just tell you what you have, what is alleged against you. One of the standard conditions of probation is that you will not use alcohol or possess any controlled substances without a prescription or in a manner that is inconsistent with a prescription, or use any illegal, dangerous, or abusable drugs or substances. The use or possession of medical marijuana is permissible unless such use or possession is prohibited by a court order or your conviction is for a violation of the Colorado Marijuana Code. The use or possession of natural medicine or natural medicine product is not permissible. And there's been an allegation that you have violated that by testing positive for methamphetamine and for alcohol. Standard condition number
And for alcohol.
and for alcohol. Standard condition number 7 states that you agree to submit to drug and alcohol testing as directed by the probation officer. That you understand that you are responsible for the cost of testing unless other arrangements have been made through the probation officer. And it's my understanding that you missed a number of UAs and a number of phone calls regarding that. As far as treatment goes, there's a standard condition number 8, which requires you to actively participate in, cooperate with, and successfully complete any referral, evaluation, assessment, or recommended program. These programs may include, but are not limited to, placement in a residential or outpatient program, counseling or treatment for drugs or alcohol, mental health, domestic violence, cognitive behavioral, offense-specific, or anger management. And that you agree to sign any necessary releases of information, and that you are responsible for the cost of treatment and services unless other arrangements have been made through the probation officer. And as of the date that this complaint was filed, that you had not signed up for any treatment. And then the last condition, number 12, states that you will comply with any requirements of the probation officer, including answering all reasonable questions asked by the probation officer in order to meet the conditions imposed by the court, and that you agree to sign all releases of information necessary for the probation department to communicate with others regarding supervision. And it's my understanding that standard condition number 12 is alleged to be violated for failing to comply with the terms of the electronic home monitoring. Lastly,
I object to that.
so
I've done 90 days on an ankle bracelet
so
already.
so what I'm doing first of all is just letting you know what the allegations are, and not whether you agree with them, but just letting you know what the allegations are.
I'm aware of it.
And then the next step I'm going to ask you is whether or not how you would like to proceed. Do you want to admit to any of the allegations,
I
or
refer you back to the notes.
okay? You don't have to say anything, but if you don't say anything further in this proceeding, then I am going to ask the people to proceed with their evidence to determine whether or not you have violated the conditions of your probation.
I work every day till late hours in the night. For 90 days, I did not do that, which disappointed many customers. I'm adverse to any of their allegations. I complied under duress without my consent, under threat of 4 years of jail for crossing a yellow line in a rainstorm. And I didn't get due process. I was denied any witnesses on my side. I was slandered in court, in open court. I still done the 90 days. I take a supplement called methylene blue. Whether that tests positive for methamphetamines or not, I don't know, and I really don't care.
Well, you should care. Because just like a professional athlete, you're responsible for what goes into your body when you're required to take a drug test. And I want everyone to remember exactly what he just said. Even he admits he doesn't know whether what he took could cause a false positive for methamphetamine. That detail is going to matter later in this video. But first, the prosecutor is about to respond to his jurisdiction argument.
But and no alcohol have I consumed. That's total out and out bullshit.
Okay. So as I said earlier, we're not here to undo what that original sentence is. And I'm sorry that you are frustrated and disgruntled. With all pleas in this jurisdiction, there's always questions about whether or not you felt like you were forced or coerced, or whether or not anybody put any sort of undue pressure on you. There's always a mechanism for challenging that later, but the mechanism is not on a hearing for a probation revocation. You were initially charged with 11 counts. You pled guilty to one of those counts, and your time was originally suspended, and the condition of 60 days of probation was also suspended, with the condition that you comply with the 90 days of electronic home monitoring. There's been these allegations that you violated. It sounds like you have disagreement about whether or not you violated. And that's really what the purpose of today's hearing is for the people to present whatever evidence they have about whether or not you violated. For me, and you're entitled to cross-examine them on that particular evidence. You will also be entitled to give your own statement as to anything that you want me to know about whether or not that you have violated. And after that, I will make a determination. When I make that determination, if you have violated, if the people have met their burden of proof, I will also have to make a determination about what the consequence should be. And we're not at that stage because I don't even know if they have enough evidence to meet that burden. So why don't we go forward now? We'll have Mr. Bema will present whatever evidence he has, and you'll have an opportunity to rebut that. Mr. Bema?
Thank you, Your Honor. If I can quickly just address the motion that I just received prior to the hearing. Essentially, the gist of it, as I can understand on a quick read, is that jurisdiction isn't appropriate because the parties aren't proper. Specifically, the objection was to the people of the state of Colorado presenting this case and prosecuting this case, but the Article 6, Section 22 of the Colorado Constitution requires actually that the prosecutions be carried out in the name of the people of the state of Colorado, and that the constitutional provision requires that in all prosecutions for violations of Colorado law, the process shall run in the name of the people of the state of Colorado, and all prosecutions shall be brought in the people's name. And that's People v. Hunter, 666 P2D 570, 1983. Also People v. Sommers, SOMMERS, 200 P3rd 1089, 2008. And so with that, that's just for the court's consideration. In the bigger, ruling on the case as a whole, now prepared to move forward with evidence we call Probation Officer Wanda Pierce.
All right. So now that jurisdiction has been established through both statute and case law, it's time for prosecution to call its first and only witness. I'm going to skip through most of the testimony and only stop when our courtroom jester decides to jump in. What you need to know is this. He had multiple probation violations for failing UA tests, multiple violations for refusing to even take those tests, and several tether violations tied to his home confinement.
What is that?
That is the standard conditions of probation.
Okay. And how do you ensure that people are aware of the terms and conditions of probation?
I review each one with them and then they initial as I go through them. And I answer any questions that they may have in regards to each term and condition.
Okay. And did you do that in this case?
Yes.
Did you meet with Mr. Zunich in this case and go through that process that you just described?
Yes.
And is Mr. Zunich here in the courtroom?
Yes.
Can you identify him?
He's in the blue shirt sitting directly in front of me.
Have I ever caused you harm or injury or loss?
Mr. Zunick, that is not the objection. She's just asking to identify
It's
you.
got to be a victim, Marbury versus Madison.
So the prosecution has the ability to ask questions right now. If there is an objection to the particular question that is based on rules of evidence, then you are entitled to make that. But he was simply asking whether or not she could identify you. So the objection is overruled.
And if I could let the record reflect that Ms. Pierce has identified Mr. Zunich.
So noted.
Yes.
Condition 1, what condition is that?
Are you referring to the first condition, number 6?
Correct. Sorry, that's a fair correction. So
Okay.
yes.
Yes, I am familiar with it.
Okay. What is that condition?
No use of drugs or alcohol
How and
unless prescribed.
was that condition complied with?
No.
And
In
What-
your opinion,
You'll have a chance, Mr. Zunich, to question her. So just make note of the questions that you want to ask her afterwards. But we're going to let Mr. Bama go ahead and ask his questions.
Your Honor, the people would move to admit People's Exhibit 3.
Any objection?
no objection. I've got questions.
You'll have a chance to ask her questions about that. It's admitted.
Okay. And so you said that this process is one where you ask the lab to look a little bit deeper into what.
Objection. Does the lab actually look for specific methylene blue
So you'll have,
as a supplement?
Mr. Zurch, you'll have a chance to ask those questions yourself after Mr. Bama is done questioning the probation officer.
So this lab goes a little bit deeper, I think, as you explained it, into what the substances are, right?
Correct.
And what was the conclusion from the lab?
Negative for amphetamine, which would be a prescribed amphetamine, and positive for methamphetamine.
And what does that mean to you?
Street meth.
And there are
Objection. What's the difference between street meth,
I'm not a
methylene blue?
lab tech.
Mr. Zunick, you will have a chance to ask her these questions when it's your turn. So let Mr. Bama continue to ask her the questions, and then you can ask her the questions that you have concerning what the lab report says or doesn't say.
Your Honor, people would move to admit Exhibit 4.
Any objection?
Yeah, I object. What's abnormal?
Okay, it's just on an evidentiary basis. So you'll have a chance to ask that question. The People's Exhibit number 4 is admitted.
Okay, so that wraps up the witness testimony. Now it's time for the living man to offer his cross-examination.
Would you like to ask some questions?
Yes.
Okay. Before you get started, I'm just going to have you ask questions. This is not a time for you to make any kind of argument. You're just going to ask questions of the probation officer. After you're done asking questions, Mr. Bama, because the burden of proof is on him, will be entitled to ask any kind of follow-up questions. After that's done, if the people do not have any other evidence, I'll give you a chance to put on whatever evidence that you want. If it's your own statement, you're welcome to do that, but you're not required to do that. And then we'll go from there. But I just want to caution you that you can only ask questions now. You can't make argument. Argument will come later. Okay? All right. Proceed.
To your knowledge, is there any test that tests specifically for methylene blue?
I don't know.
And do you know if methylene blue would test hot for street meth or amphetamines or Ritalin or any others? Do you know that?
What I do know is anything that tests positive for methamphetamine, we are asked to have you stop unless you provide a prescription.
It's sold over the counter.
Okay.
And you're not familiar with it. Have you ever tested for methylene blue? Have you ever even heard of it?
Yes.
Oh, you have? Was you aware that it possibly could cause a
I
positive?
do not know that.
So, not knowing that, you admit that you don't know whether these reports are 100% correct or not for a positive test.
It is positive for methamphetamine.
And you know that how? I thought
Because
you
of the
haven't
test.
dealt with methylene blue. You
No,
don't know whether. The
these
question
tests are
is do you know
positive.
whether or not methylene blue can test positive for meth?
I do not know.
Okay. Then do you know the range of distance that a person can be away from the electric home monitor before it says that he's gone or something? Do you know how close I have to be to it?
No.
Is it possible that when I get up in the middle of the night to urinate, that I got out of range of that? And you can see on the reports that it was like a 3 or 4 minute vacancy away from it and then back into contact with it. Is that possible?
I don't know.
So what you're saying is you're going off presumptions that you have no clue. You've just admitted that you don't know whether methylene blue would test, which is a legal supplement that's sold over the counter. You don't know whether that'd test positive or not, correct?
Objection argumentative.
Sustained. Go ahead and ask your other questions. Remember, you're going to have a chance to make argument that is a reflection of what she has said. So once she has given you the answer, you can use that answer later in your argument if you choose. Okay, so just keep on with your questions.
So there was times when I did miss them tests because I was over the hill in Nucla and I test and live in Delta and I couldn't get back in time. I'm a plumber, and when I have somebody's gas or water shut off and it was the winter, it's a possibility that, I didn't make it back in time. And most of the time I tried to make it home.
I need you to phrase it as a question.
Well, then answer the question.
I'm sorry, I don't know what the question was.
It was,
I think the question was, is it possible that the reason that he missed was because he was at work, and given the location of his work and his residence, that he was not able to make it back in time?
I was very clear when we discussed those misses that that you were on an electronic home monitoring, that you must leave earlier to make sure that you make it back.
How many times exactly was I more than 45 minutes
Can I
late?
finish, please?
Yes.
Okay.
Let her answer the
To
question.
make it back in time for that UA, that you find out about the UA you can find out about the UA at 6 a.m. and therefore have to do it before the time that you're supposed to arrive back home. And we did mention this. I talked to you about this about 3 or 4 times. So yes, it is possible.
Do you agree that I had told that I am a plumber, and in my line of work, if I happen to have a water break or somebody's gas is shut off at the winter and it's beyond my control, I cannot leave them? And how many times exactly was I more than 30 or 45 minutes late getting home? Do you have that information?
I do recall talking to you about this, and that the electronic home monitoring system was probably not fit for your situation.
Regardless of that, is that a possibility?
Yes,
Do you
we did have
understand?
conversations about that. Mhm.
have I displayed aggressive or unfit behavior towards you through all of this? Or was I called in and one time you did give me a weekend or a day that I could go to Saguache and finish a job for an inspection? Did you not grant me permission
Yes.
to do that? But yet I'm violated. That's one of my violations alleged. Correct?
That one was accepted and it was put
Oh.
into the system.
Can
That
you
one
provide that
event.
information to me? That
It
it was accepted?
is in my notes. I do not have them.
I don't have any other questions. That I'm not a lawyer, and I couldn't find a constitutional lawyer to save my life.
You know what else you can't find? A unicorn in the wild, because they don't exist. And neither do actual lawyers who think sovereign citizen arguments hold any legal weight.
Chance, do you want to say anything? Do you want to testify on your behalf? Do you want to offer any kind of evidence? You don't have to. You are not required to, but you are certainly welcome to.
I understand. I get that. I just would like to say that, I've done the 90 days. I disappointed several customers. It put a kink in me. And, the reason I haven't complied is because of the file for revocation since then. And so, what's the point? And then as well, the original presiding judge over this that's handed down the sentencing, he didn't have the integrity to keep his position. Who's handed down these to a working man? I haven't been in trouble for 30 years.
Mema, do you want to make argument on whether you've established revocation?
Yes, just very briefly, Your Honor. Mr. Zunich has not complied with the conditions of probation. He essentially did what he wanted. He's not a good candidate for probation.
Objection.
Let him argue, and then you can make some argument and explain why you think you are a good candidate, okay?
And that's borne out in the refusal to test. It's borne out by not complying with the EHM requirements. And I think this is I think there's more appropriate argument for sentencing on that topic, because how this plea actually came into place, I think is important. It's important for sentencing. It's not relevant right now, but I'll have more to share about how this plea came about and what it is.
Under duress.
But in terms of the probation revocation itself, it's clear that he wasn't testing. He admitted that he didn't test. That establishes at least one condition.
Since the revocation.
The tests that he did take were positive for methamphetamine. I understand there's some reference to an over-the-counter substance, but that's the point of the Courtroom tests. Those tests are to delve deeper into the first report and test for street drugs, which is what the probation officer, Ms. Pierce, testified that test is for. All of those tests were positive for methamphetamine. So that's another condition that's clearly been violated. There's been no attempt to establish treatment. That's undisputed. So that's another reason that probation has been violated. So the people do believe that there is grounds to revoke probation here, and we do ask for probation.
All right, Mr. Zunich, do you want to make argument as to why you think that the people have not proven that you have revoked your conditions?
I just refer back to the notice I filed, and I'd like a living, breathing man to point me out across the room and utter my name, that I have done them harm, caused them injury or any loss, and I would be fine to compensate anybody that I may have harmed during any of this. And if without a victim,
Well, let me go ahead
and the state can't be a victim because the state is the state. You cannot be party to prosecuting charging and trying for monetary gain the same case. I refer you to Marbury versus.
I refer you to the nearest superglue buffet while you're there enjoying lunch and dinner. Maybe take some time to actually read Marbury versus Madison, because if you did, you'd realize it says absolutely nothing close to what you think it says. Now it's time for the judge to rule on whether there was an actual probation violation.
All right, let me begin with the first thing that we have to do today, and that is decide whether or not you have violated the conditions of probation that were established in your sentencing order. Before I get to that, though, I'm going to address the jurisdictional issue. Essentially, what you're asserting to this court is that this court lacks jurisdiction, and Mr. Bama is correct that Article 6, Section 22 does require the people to carry out the prosecution, and that is here in San Miguel County through the district attorney's office. So I do find under the authority of People versus Hunter, 66 P. 2nd, 570, 1983, and all of the subsequent cases that have been decided since then, determining that that this court does have jurisdiction to decide whether or not your conditions of probation have been violated. So in conformity with the statute that directs me as to the mechanism that I am to follow about whether or not you have complied with your conditions, I do find that you have violated your conditions. And let me talk to you about what my specific findings are. One of those findings is that you have used drugs and alcohol. I didn't hear you say anything about the marijuana, which was one of the violations. I didn't hear you say anything about the alcohol.
Yes, objection. Yes, you did. I did object to the alcohol. I haven't drank none.
Okay. What I do know is that there is lab reports that have indicated that on at least 3 occasions that there were positive tests. One of those tests was from a collection on 11/13, or one was on 11/21 for amphetamine and methamphetamine. Another was on October 18th for amphetamine, methamphetamine, and THC, and another one was on 9/16 for amphetamine and methamphetamine.
So excuse me, may I?
Sure.
So you're not considering and taking into account anything about the methylene blue, the supplement that?
So Mr. Zunick, you have asserted that you were taking an over-the-counter medication, and you have asserted that that particular over-the-counter medication would test, if tested, would test positive for methamphetamine. But I just don't have any information about that particular
So
drug.
how can you make a ruling when you don't have the information?
It's the people's burden to establish that there were violations.
People haven't met that burden.
They met that burden by establishing that
I object.
there was lab results that came back positive.
And
You attempted to rebut that, and
You
the
just
court
threw my
finds
rebuttal out.
the court finds that you were unable to meet that you were unable to rebut the presumption that is given to the people based on that lab result. The other violation that I find is that you were instructed to test, and that you didn't comply with that on numerous occasions. I heard evidence that you had missed some of those tests, and that was because of work requirements that you had to go to, and it was a result of not being having to deal with, as a plumber, various individuals that had problems that required urgent attention. And given the location of the testing from either your job site or from your resident, I understand that you did miss tests. It's just that you have a mitigating reason for that. So I do find that the people met their burden of establishing that you missed those tests, but I'm going to consider the mitigation of that at the next stage of this proceeding. The other one condition was regarding treatment. The probation officer testified to the fact that as a condition, you were required to get started. She provided you the contact information, and that between the time that she provided you that contact information and the filing of the complaint, there was no record of starting any sort of DUI classes or any DUI treatment. And subsequent to the complaint, I think you have admitted that you didn't seek out any treatment because, as you said, what's the point? So I find that the state has met their burden, the people has met their burden of proof in establishing that you have not complied with the treatment requirement of your probation. And then the last condition relates to electronic home monitoring.
Nobody knows whether it takes into accountability that you walk more than 2 or 3 feet away from that monitor. It says you're gone.
So let me finish with my findings as to the electronic monitoring. The people introduced evidence to establish that there were that it was very difficult to monitor, and that there were times that he was out of range. I did not have any information to establish whether that was intentional or voluntary, or where he was. And so as to the electronic monitoring, I am going to find that condition has not been violated. But that does leave us with 3 conditions that were violated. And so I am going to find that your probation should be revoked.
All right. So the judge finds that multiple violations did in fact occur. A few allegations were unsubstantiated, but enough were proven to justify revocation at this point. The judge has a few options. She can keep him on probation, with or without jail time or fines, or revoke probation entirely. But before we get to sentencing, let's hear what the prosecution recommends.
That leaves us in a position of making a decision about what should happen now that your probation has been revoked. And so I'm going to ask first Mr. Bama to make argument as to what the consequence should be, what that sentence should be, and then I'll give you an opportunity after he is done. Mr. Bama.
Thank you, Your Honor. So this, the underlying plea here was a plea to a 3rd DUI. And just to give the court some background on how this went, Mr. Zunich was self-represented throughout the entire process. He was competent. I mean, he filed motions. We had full-on suppression hearings. Those were ultimately ruled on. This plea, which was at the offer was minimums for a 3rd, was entered the day that the trial was scheduled to happen. The jury was here. The jury was summoned. People were here, and we were ready to go, but it was in chambers before the trial started that we discussed this, and ultimately Mr. Zunich wanted to move forward with it, and that's what led to the electronic home monitoring. That 90 days electronic home monitoring was something that nearly never is offered in a 3rd. That's almost always a 60 days jail. However, he argued for it himself. I argued for the jail in this case because that's the standard sentence. He was able to persuade the judge to get the 90 days electronic home monitoring in order to keep his job. But then since probation, he's not interested in going to and checking in on probation.
Have you told her how many
Hold on,
years?
sir. It's not your turn. Based on the fact that he had positive tests for meth, this is a driving under the influence of meth case, is the underlying case. And then we have these tests that continue to show him to use meth. And guess what? He's driving. He's on the road. So, and he's not getting treatment. it's
I have a
it's a
driver
very
that drives for me.
it's a very dangerous situation, I think, and I think it's a lack of accountability. I personally, I think he does work hard. I believe that. He is adamant about that, but there needs to be some sort of consequence for the DUI, and his engagement with probation wasn't there. And based on what I've heard from the probation officer today, and this, people that fall out of compliance on probation, they just don't say, forget it. Like, we're going to go through a revocation hearing anyways. They try to convince the probation officer and the people that they are a good candidate for probation. Mr. Zunich has taken the exact opposite tact here and said, I don't want to do it. I'm not going to do it. Let's find out what happens. I made an offer of 60 days open prior to this. That wasn't accepted. Do I think that jail is appropriate here? I do. Do I think that he needs to do what he's fully exposed to? No. But I have argued from the beginning that 60 days jail is appropriate on a third DUI, and I remain of that position. I'm not asking for any additional jail unless the court thinks that's appropriate for his behavior on probation. But I do think that that's appropriate. And I also don't think, I would like to see him on probation just for testing alone, right? Just to stay on test to make sure that sobriety is, and that education that he's getting. But I have a feeling we're just going to be right back here again, and a jail closeout might be the most appropriate way. But ultimately my goal is to make sure that he's safe and not using drugs. That's ultimately my goal. That's what probation was trying to do. And we haven't really made any progress.
And so, what do you believe he's exposed to?
According to the plea, he has, let me just bring it up so that I get it exactly right.
It's 364 days suspended.
Yes, he has an additional 1 year of jail suspended on condition of successful completion of probation. So there is a year of jail on the table. Correct.
For a victimless crime.
And you're asking for 60 days.
Yes.
And are you asking for probation to follow?
That's the real tough question, right? Because I think that's really what this case calls for. But
We're still unclear about the
Mr. Zunich,
methylene
hold on.
blue.
Mr. Zunich has been given that chance, and he's done nothing. And his attitude seems to be that he's not a good candidate for probation, even though I think that the monitoring and the education is something that would do him a great benefit. We've already tried to force him, right, by sentencing him to probation, by ordering him to probation. We've tried to get him to do that. And I'm more than willing to give people a chance that want a chance, right? People that say, look, I know I screwed that up. I want to go back. I want to do the classes. I'm going to get back on testing. And I'm happy to give them that chance. I'm not hearing that that's what he's even asking, right? Mm-hmm. And it doesn't seem like, if he does and he puts something behind that, happy to consider it. But this probation revocation has been pending since last year, I can't remember the exact date, but the end of last year. And every time I've tried to, have conversations with them, it's just, there's nothing happens.
And so what is your recommendation to the court?
So for probation, can I consult with Ms. Pierce for just 1 second?
Yeah.
It's just a closeout, no more probation. And that's based on Ms. Pierce, who's had far more experience with Mr. Zunich than me. That's based on her position.
Have any of the fines been paid?
Not that I'm aware of.
Okay, thank you.
The prosecution recommends full revocation, along with a 60-day jail sentence. But fairness requires hearing from the defendant too. So now it's his turn to explain what he thinks is appropriate.
Zunich, would you like to make an argument on your behalf about what your sentence should be?
Yeah, I mean, you found me not to be in, you found me to have complied by your own words. You didn't find me with the electric home monitoring. Does the 90 days on an ankle bracelet mean nothing that I've already went through?
So do you have anything else you want to add?
Well, after my court was done, then the judge, within 2 weeks after that sentencing, he was disbarred or whatever it is. He's not on the court no more because of misconduct. And that's made me rethink the whole thing. And so, honestly, I do nothing but work. I don't hit the bars. I don't go out. I don't do anything but my job and my business. And I've been railroaded through this. I don't feel, it was a rainy night. There was no, as I said, there's no victim. I have no victims. And there's no, I just feel completely railroaded by all of it. When I've been exemplar how many years was it for the first 2 DUIs? Do you remember that, Mr. Bayman? 26 years and 27 years, 27 years later, I get a DUI and I don't even drink.
Do you have anything else you want to add?
This is a travesty. It's not justice. In my opinion, there are other things that need to be prosecuted than a hardworking man being run over the coals.
Well, let me say this to you, because I'm prepared to announce what my sentence is going to be.
And that you're saying that today? I thought we was going to have another hearing and all this other.
No, your sentencing is today.
And I would have to so whatever you sentence me to, it starts right now. I don't even have time to get my affairs in order or anything.
I'm going to give you time to get your affairs in order.
Okay.
Okay. So I want you to hear what I have to say.
And this right here is where things start going sideways. Giving him time to get his affairs in order before serving his sentence turned out to be a terrible decision. That's exactly why he later refused to show up for the court hearings I covered in the previous video.
But I want to respond to a number of the things that you said. And one of the things that you've talked about repeatedly is that there was a judge, my predecessor, who stepped down from his position who has stepped down from his position after he was suspended. I don't have any information that would suggest to me, having reviewed the entirety of the court file before this proceeding, that there was anything amiss in the particular proceedings that led to you making a decision to plead guilty.
I was
so
denied calling any witnesses or endorsing anybody
So
at the trial. All I had the ability to do that day, I was informed, was to cross-examine. I couldn't endorse any witnesses. My due process was not.
So, Mr. Zunich, the decisions that you made about how you wanted to resolve your case, you made them. I was not privy to those decisions, but I see nothing in the record that would suggest that there was anything amiss. In fact, what it looks like to me is that it was a fairly favorable resolution, and it put everything on your shoulders about working through it. Your jail time was suspended. You had to comply with electronic monitoring. But most importantly, what the probation office wanted to see you do, what the people wanted to see you do, and what the court wanted to see you do was be successful and get the help that you needed. Because when you get to a point where you have a third DUI, that tells us that there is a problem. Whether the first two were years ago, the reality is you pled to a third DUI. That's all the information that I have. You were required to sit down and go through an evaluation process and go through the treatment process. Had you sat down and done that treatment process, we would probably be in a different situation. But you didn't sit down and do any treatment. You missed several of your DUIs and you tested positive. Had you come to the probation office and said, hey, here is the drug that I have been taking over the counter, would you please
did that.
ask your lab to go ahead and test this medication and see if it tests positive for methamphetamine?
I had brought it up.
I'm not talking about bring it up. I'm talking about bringing her what it is that you were taking so that it could have been tested. But the fact of the matter remains, and I think Mr. Bama's point is spot on this, is that probation attempted to work with you. You didn't work with probation. You didn't attempt to get into treatment. And even after they took the step of filing a complaint to say that your probation was, that they were moving to revoke it, you didn't say, hey, wait a minute, this got out of control. I'm going to go through and
I
go ahead
actually
and take the
did.
treatment.
I actually
Where
did.
is the evidence, Mr.
But
Zip?
it fell on deaf ears.
I don't see that you have signed up for any sort of treatment. I don't see that for the $3,213.50 that you owe, that you have made a single payment on that. And yet you're telling us that you're a hard worker, that you are, all that you do is work. Mr. Bamey even says that you are, and you've taken no steps to make a single payment, not even $50.
To be fair, it's kind of hard to make any payments when you're allegedly spending money on a quarter kilo of methylene blue every month.
So you put me in a difficult position because you were exposed to a sentence of a year. You were then in a position where they agreed that if you did the electronic home monitoring, that you would be that you could avoid the 60 days of jail, and that was granted to you, and that was very favorable. And I found that here in this case, that the electronic monitoring, I just wasn't sure that they had proven up that particular condition. But I did find that all of the other conditions that they alleged were violated have been violated. So now I have to decide what is the appropriate consequence? Because when I hear you speak and you talk about the jurisdiction of this court and you talk about what Judge Murphy did and you talk about all of these other things, what it tells me is that you do not have a respect for the process that this court is obligated to impose. It is the laws of the state of Colorado that we have to enforce. So I'm left in a difficult decision because I like when a person is working hard. That's important to me. I heard what you said, that you have somebody else who drives you, and so that you're not actually driving. I do not think that you are a candidate for probation. So I am going to impose a term of custody, but it is not going to be the 60 days. It is going to be 45. I will give you a chance to tell me when you would like to surrender to serve that time in custody. And then you can serve that time in custody. So that will give you a chance, give you 45 days, or it will give you a chance to get your affairs in order. You will be placed in custody. And then when you're done with this case. You don't have to get any treatment. You don't have to report to the probation office, and this will be done, and we won't see you again. But there does have to be a consequence for your actions, and that's what my sentence is going to be. When would you like to surrender?
Can you give me a couple of days to figure that out?
I need to have a date today of when you would like to surrender, but I'm willing to be flexible and give you
I've got a
time.
project under bid right now, and I need to consult on that to find out if I have time to get my obligation on the bid.
Tell me, I don't know much about what that looks like, so tell me what's involved with this, because I do want to be flexible. I don't want you to miss out on work, but I am.
It's a new shop that's being built in Norwood, and it's, the bids have already been granted, the contracts, and I'm not real positive when they're going to break ground. They were supposed to break ground last week, and it still hasn't. So I would like to talk to them, the general contractor, and find out exactly if it breaks ground, if we break ground in the next week or so, I can have my rough in and my underground done and then do my time and hopefully be out in time.
And how long would your rough-in take?
10 days, week and a half for to run the pipes in the underground that get poured underneath the slab.
Okay.
And I just don't know I don't know where it stands right now. But I could have that answer by the end of the week.
And I don't have any problem giving him more time. It's in this court, it's pretty regularly. Let's do some jail time during off season or things like that. I mean, that flexibility is fine. And I mean, that sounds.
Could I do 15-day stands?
That we can't do.
We have to do it continuously. And so we're going to do the 45 days continuously. I think it's a matter of when we're going to actually impose a start date. So I am, Mr. Bama, do you have a recommendation on whether we just continue this hearing to give him the opportunity to decide, or whether we set it for 30 days out for a surrender date?
Yeah, just like issue a minimus for 30 days from now. I'm totally fine with that. I don't have no objection to that. I think that's because I know Mr. Zunich, I think, comes from Delta, so it's not an insignificant drive. So the less appearances happen, we can just set the date, and if 30 days is going to be enough for the process that he needs to play out, no problem.
Okay, I'm not sure I understand what you're saying. So set it for surrender in 30 days. And then if that is not enough time, do you have a position?
Oh,
I mean, my position is I think 30 days is enough time based on what you're describing. If they start this project in the next week or so, the 10 days. So my inclination is today is, why don't we say a surrender date of May 1st? Is that a weekend?
It is. It's a Friday.
Okay. Why don't we say Friday, May 1st will be your surrender date? That gives you a little bit over 30 days to get whatever you need done, get not only your affairs in order, but if you have this job, to get this job done. Your sentence is for 45 days. And you do still have a fine in place that needs to be paid. So I would expect to see that fine gets paid, or then you'll have collection. And that will be the sentence.
All right, guys, that's the end of today's video. Like I said, he did receive a jail sanction along with a discharge from probation. But despite promising to turn himself in, he ended up going on the run instead. And because he ran and then refused to appear in person for his other pending cases, he now has additional warrants out for his arrest at this point. It's safe to say he's going to be spending a lot of time behind bars once he's finally caught. And when that happens, I'll be here to cover for you at SO. If you liked the video, hit the like button. If you didn't, hit dislike. But either way,